While the public protector is considering whether to appeal or to apply for direct access to the Constitutional Court after ruling against her, the North Gauteng High Court set aside her report into the Estina Dairy Farm Project. The public protector's spokesperson, Oupa Segalwe, joins me now for this conversation. Oupa, where to from here for the public protector? And as the Office of the Public Protector, how do you receive this ruling that was handed down today?
Well, let me start with the last question. It definitely took us by surprise because the judge had initially indicated to the public protector that she would not be handing down judgment in this matter until the Constitutional Court has handed judgment on a matter of personal cost, which is linked to that particular matter. But be that as it may, the public protector disagrees fundamentally with this particular judgment. For starters, she's concerned that, among other things, in setting aside the entire report, the ruling might be interpreted as though the court condones the maladministration attributed to the parties against whom adverse findings were made in that particular report. But rather than arguing the merits of this case in the media, the public protector will express herself fully in the court, whether she's granted a leave to appeal or direct access to the Constitutional Court, as you have already mentioned. However, we just want to make a few points with regards to why she disagrees with this matter. First, she could not have investigated allegations contained in the third complaint. And that is the complaint that reached her office in May 2016, because at that point, the investigation was pretty much done. Two, she could not have investigated issues that were in the public space at the time, such as the Gupta leaks, because you will recall that it was this very office in a report titled State of Capture that directed that the Commission of Inquiry, which is currently sitting in Joburg, be established to look into claims of state capture. So it doesn't make sense that there are people who expect her to have launched a parallel investigation to look into exactly the same thing that the very same office she occupies deferred to the commission. Lastly, there has been talk about that she changed the provisional report and so forth. We just want to make the point that a provisional report is a working document, which can be equated to a draft judgment of the full bench, which obviously gets circulated to other judges for comment, and therefore is not final. And until such a judgment is officially delivered, it is not a court judgment. And further, it enjoys no legal status. So this suggestion that she should have just rubber-stamped the provisional report that she found is a bit curious for us.
So in this light, are you going to then, as an Office of the Public Protector, you're going to be appealing this ruling now, or are you going to be applying for direct access to the Constitutional Court to perhaps further the matter on it? Because, some strong words were said regarding this report, and I'm sure you'd appreciate it all, but to call the Public Protector's report as, number one, unconstitutional, the very same role that she's there to uphold the Constitution, for it to be referred to as unconstitutional as well as invalid. Never mind the fact that 200 million, rand in funds which were meant for people was violated, but to call her, when the report that she's done as unconstitutional just speaks to the gravity of the situation and perhaps even the view and the credibility and the question of credibility of the public protector herself.
And that's essentially why the public protector is currently weighing her option as to whether to turn to the very same court to apply for leave to appeal to the Supreme Court of Appeal, or to apply for direct access to the Constitutional Court, because these are matters of constitutional nature. We are definitely not taking it lying down. We disagree fundamentally with it, and we will be appealing this judgment.
But before I let you go, which one would be the viable solution for the office at this moment in time? So you are playing with the two options, but what I'm asking is then, which one is the more viable option? Are you going to be going to the Constitutional Court, or are you going to be appealing?
The ideal one is to go directly to the Constitutional Court, but then there's a process that they might say, no, you ought to have went that route. So she's just toying around with the two ideas, and on advice she will make a decision. But the point to be made is that we will definitely appeal this judgment.